Welcome to the Quillette podcast. I'm your host, Jonathan Kay, a senior editor at Quillette. Quillette is where free thought lives. We are an independent grassroots platform for heterodox ideas and fearless commentary. If you'd like to support the podcast, you can do so by going to quillette.com and becoming a paid subscriber. This subscription will also give you access to all our articles and early access to Quillette social events. And this week I have a cold. That's why I sound like this. Not looking for pity, just explaining why my voice sounds different now compared to the conversation you're about to hear, which was recorded last month. That conversation is with Harvard Law School professor Cass Sunstein, an eminent legal mind who was famous even when I was at law school back in the 1990s. He's also something of a book-writing addict. As he will confess in our interview, he can't even remember how many books he's written, like even in round numbers. On Amazon, his catalog of published works runs on for 17 pages, and that doesn't even count all his many peer-reviewed academic papers and journalistic articles. Last month, he spoke to me for the Quillette podcast about his new book, Campus Free Speech, A Pocket Guide, which, as you might guess, was inspired by his desire to work out some of the thorny questions surrounding free speech that arose from the aggressive anti-Israel rhetoric that's been on display on his campus, and many others, since the Hamas terrorist attacks of October 7, 2023, and the punishing Israeli military response in Gaza. While many of Sunstein's books are highly theoretical, this one is more practical. He runs through a long series of campus scenarios involving provocative slogans, from the river to the sea, globalize the Intifada, that sort of thing, and analyzes whether they are protected by the First Amendment to the US Constitution. And while this mode of legal analysis is, by Sunstein's own admission, parochially America-centric, he presents it as a template for the way universities and other large institutions around the world can make principled decisions about what speech to allow and prohibit. The idea here would be that institutions would borrow, by default, their own nation's constitutional speech standard, which in the US, of course, is the First Amendment, and employ that standard as a kind of baseline, perhaps modifying it as needed to fit the particular circumstances of the institution. The result, Sunstein tells us, would be a regime of speech regulation that would be at once more liberal and more predictable, sparing institutions such as, say, his own Harvard University, the need to create such standards from scratch. Here's my interview with eminent Harvard law professor, and I was pleased to learn, Quillette fan, Cass Sunstein. You have an expression here from Justice Robert Jackson. You call it the greatest sentence ever written by a member of the United States Supreme Court. Compulsory unification of opinion achieves only the unanimity of the graveyard. That's pretty good.
Yeah, it's really good. So Justice Robert Jackson was the greatest writer our Supreme Court has ever had, even better than Oliver Wendell Holmes. And of his beautiful writing, this was the best sentence and the most heartfelt. So let's say it again. Compulsory unification of opinion achieves only the unanimity of the graveyard. That's actually true. And there are lots of different kinds of graveyards. Of course, there are places where everybody's dead, but there are places where everybody's really quiet. And that's a kind of graveyard too. And free speech principles are designed to ensure that communities and towns and cities and universities and companies are not graveyards.
Yeah, I can think of a few graveyards of the mind that permeate my own society. So your book, essentially, obviously you're an expert in US law. You're sort of urging, it sounds like in a modest, humble way, an extrapolation of principles in the First Amendment geographically to other countries, but also an extrapolation in scale. So say, well, this is something that binds the US government, it binds states through the incorporation clause, but it can also be used on a voluntary basis, of course, and private colleges, private universities. I guess theoretically, even corporations could say, you know what, instead of convening 17 different committees about what people are allowed to put on Instagram, we're just going to take this toolkit, handily referenced and summarized in Cass Sunstein's 87th book, into our own organization. Is that kind of what you have in mind here?
Broadly, yes.
All right.
So let me tell you, if I may, about the origins of this book. So during the protests of last spring, I started writing kind of notes to self about how to handle various problems. And I found that some of them involved student activity, maybe putting down tents, maybe taking over a building, maybe saying from the river to the sea, maybe saying something positive about segregation, and then faculty things like professors protesting what they deemed to be a genocide by Israel, or students or professors saying Israel should never have been created, or something, or professors saying that affirmative action should be abolished, or professors saying men are better than women at math. And then I was writing these notes to self, and they started to become longer and longer lists of scenarios. And then it occurred that we need some general principles to come up with how to handle them. And then if you spend a lot of time, as yours truly did on this, you'd end up with an understanding of how the constitutional principles would apply to these problems. And that would make life a lot more manageable for institutions that were otherwise struggling with trying to build a house from the ground up. Then the question is, as you're asking, well, should this apply to private universities as well? And it's unclear, in various countries there are different rules whether constitutional strictures apply to public universities, private universities, sometimes even the terminology is different, and there we go. So the thought was that for, let's say, Columbia University or Stanford or Harvard, my own institution, or the University of Chicago, which used to be my institution, the use of First Amendment principles is a massive step forward, because these are institutions that should be teeming with diverse ideas, that should be welcoming of different judgments of fact and different opinions. That's what a university needs. And the First Amendment is a really good way of getting there. Now, you might think that to adopt free speech principles of the standard sort in the university setting is not a great idea. Now, why might you think that? You might think that if you're a religious university, that there are some things that just aren't allowed here. Maybe that's right. That's a fair thing to discuss. Or you might think that a university needs to create safety for students so that certain kinds of things, let's say blasphemous things or unpatriotic things or racist or sexist things, aren't allowed there. Now, on my view, as a first approximation, that's all wrong. What's needed at a university is safety for ideas, not safety for feelings. Whether a private corporation should be bound by the First Amendment by its voluntary choice is a very different question. So you could imagine Apple saying, we're going to apply First Amendment principles here, and that's going to organize how we all work. That's actually a really interesting possibility, but it might be that Apple or some other company would say, it's really not suited to us because we need a kind of communal solidarity at our company. And if people are saying various things, it's kind of incompatible with being an employee here. And some version of that is reasonably believed by many companies. Certainly that to be loyal to your company is something companies not unreasonably want, and free speech principles do not mandate loyalty. They allow disloyalty. So whether this is all well suited to the private sector corporate world is not so clear.
You say a lot of so-called free speech controversies could and often should be handled basically with casual conversations. You give an example in passing of somebody, you were teaching a large class and somebody was dropping F-bombs, and you took them aside and said, look, you have a First Amendment right to drop F-bombs, but please don't. It's not necessary to make your point in class. There was an example, I don't think it's contained in your book, ripped from the headlines example at Harvard, where you had, I think it was a fairly prominent dean who wrote an op-ed in Harvard's main in-house student publication saying there are all these professors who are bringing Harvard into ill repute by criticizing us in a very toxic way about, I forget exactly what, DEI policy, some of the Israel-Gaza stuff. There was a whole Megillah about Claudine Gay and testifying in Washington, and then she resigned. And this dean broadly attacked academics at Harvard who made hay about all that stuff and were kind of airing Harvard's dirty laundry outside the quad. I thought it was a creepy op-ed because it sort of vaguely suggested that there might be professional ramifications. But I also thought, you know what, he has a right to free speech also. And if he wants to say creepy things in the school newspaper, he has a right. And not everything has to be a First Amendment issue.
So let's start with the F word. I did have a student who in a large class used the F word, and I'm not sure if I handled it ideally, but I reacted in a way that suggested that it was surprising that he used that word. So I wasn't stern with him or anything. I was instead, I acted as if I was amused at the unusual nature of the F word being used in a very large class. And I liked the student, and I may have said something like, I've heard that word before, but not quite in this setting. It was a little bit of an effort to enforce a norm, though there was no suggestion on my part, never occurred to me that the student be punished. It's just that there's a norm of, we talk in a certain way. And I think that's very important in universities to have enforcement of, let's say, civility and considerateness and respect through norms rather than through law. And if people are at times not respectful or not considerate, that's okay too. Now, there are versions of it that aren't, but I agree with what you said about the substance of the op-ed or whatever it was. It was, I'm going to speak strongly here, it was kind of Stalinist. So to say that at a university, those who speak very negatively about the university and its practices or its administrators might reasonably face some sort of sanction, that's
creepy. The legal term is creepy.
I was going to say something like not ideal. And for someone who was in a position, as I think the author was, and I applaud you for not naming him because all of us are entitled to make a mistake, and I'm sure have myself. I wouldn't want to demonize someone who made a mistake.
He was angry because he's proud of his university and he sees people airing dirty laundry, and he has an emotional response, which he put into this op-ed.
I really love my country, and I'm very honored and lucky to be an American. But if people say terrible things about America, they shouldn't be punished for that reason. And Harvard can easily handle its faculty saying negative things about its people, and that's okay. So I hope the author regrets it. The idea that he's entitled to free speech too is clearly correct. But if the head of, let's say, Princeton or McGill said something about a virtue of being at Princeton or McGill is loyalty to Princeton or McGill, and we don't expect you to say anything negative about us, or if you do so, keep it inside, don't tell anyone else, that wouldn't be a very good moment for Princeton or McGill that universities benefit from and need. Even publicly aired challenges to how things are going. And, there are things that could cross the line, leaking things that are confidential. That's not good.
Yeah, then we get into the area of whistleblowing, which is kind of a gray area of employment law. And I want to get back to this idea of norms. So I recently went back to Yale Law School for my 25th anniversary of my graduation. I saw all the people who are almost as successful as you in my class, like Cory Booker, and we had a fantastic time, but I took the opportunity to kind of bring myself up to speed on political developments at Yale Law School. And at the time, this is kind of before the administration laid down the law a little bit, there was all these groups who were marching into room 127 to shut down speakers they disliked. And it wasn't like the head of the KKK was coming. It was kind of like people like you, or dare I say me, who just were kind of free speech proponents and people who believe men and women are different. And I talk to students there because even when I'm at a school reunion, I'm a journalist. So I started interviewing students. And the issue of norms crops up because people, especially young people, are so heavily invested in the norms of their social media political clusters that those norms often override the norms of the institutions to which they're more formally part of, like a company or a law school in this case. And so like the norms in many highly progressive milieus are, you're not allowed to say stuff in favor of Israel. You're not allowed to say men and women are different. In the same way, if you go to Liberty College, there are certain norms there. Like if you're a religious observant Christian of a certain type, you're not allowed to say polyamory is good. Is one of the problems here that it's not like maybe 20 or 30 years ago when you could expect that the dominant norms of society at large or an institution at large would be prevalent, but the norms imposed by social media silos are so dominant that you have these students, first-year students at Yale Law School, who are so fired up with the norms within their silo that they take them into the classroom and literally scream over invited speakers. So norms are part of the solution, but they're also part of the problem, right?
I'll tell you a story. A number of years ago, this isn't recent at all, a student came into my office, an undergraduate at Chicago, and said she wanted to write a paper on how law constructs the body. I said, what does that mean? Law constructs the body. And she looked at me with amazement and she said, what, law doesn't construct the body?
Uh-oh.
And I said, I'm not taking a stand. I just like to know what is the meaning of the sentence. And this was a very intelligent student. And clearly she'd been in a place where the idea that law constructs the body was a self-evident truth. And she took me to be denying a self-evident truth. And I didn't even know what she was talking about.
Anybody over 35 or 40 has had this kind of conversation with somebody.
So I'd like to say that there's a sense in which law self-evidently does not construct the body. So my body doesn't have a lot of hair up there, you may have noticed, and that's not a product of law in any respect.
To our knowledge.
I have 2 arms, and probably you do too, and that's not legally constructed. So there's something she had in mind, but there was a shibboleth or something that was just widely held. That's an example. So let's distinguish among norms. So norms of civility, mutual respect, courtesy, these are really good norms. And my understanding is that they're by and large followed at Yale as at the University of Toronto. And so that's great. That's a kind of norm. But we want to be careful about that, because if people want to say something agitated and maybe not that civil about an issue that concerns them, that they have a right to do that. And it might be right that they do that. So there's that. Norms, I think in your sense of political beliefs that are very firmly held and maybe not questioned, and which are a little bit like an implicit law of the land, where if you say something inconsistent with them, you're in big trouble. So I love the kind of neutrality of the way you phrased it, that it might be that at a left-leaning institution to say something like abortion is murder, or that men are different in the following respects from women, that there's a list and that's biological, that would be verboten. Whereas in other places to say something like affirmative action is great, or that women should have the right to choose, or something about prayer that would be dismissive of prayer, that those things would all be impermissible and people would self-silence. Now, it's complicated how to think about that. I think the fundamental truth is that academic institutions should be careful not to allow norms to turn into censorship machinery. So if someone wants to say affirmative action is terrible for 7 reasons and women should have the right to choose abortion, the educational institutions need people who are saying things. Let's just stipulate that in both cases they go against the grain. I've been very pleased to see, I think maybe I've been lucky, that in my own teaching at Chicago and Harvard, and I'm super lucky to get to teach at those places, intellectual openness is the coin of the realm. So I taught a seminar on the Supreme Court where there are students who are left of center, students right of center, students who are very right of center, students who are very left of center. And whether they're engaged in some self-censorship, I don't know, but I do know that they say what they think. And so their fellow students hear someone saying something that's very supportive of conservative Supreme Court decisions and students hearing people be very sharply critical of conservative decisions. I think, Yale needs that. So if we have what I've heard, I don't know to be true, but that you would know better than I, that there are large pockets of Yale where to depart from a left of center orthodoxy is not to be kicked out of Yale or to be put in jail in New Haven, but is to risk the wrath of your classmates. That's not ideal.
A few years ago in Canada, there was legislation put forward to ban Holocaust denial. It's a very difficult conversation for a free speech supporter to have. I put myself in that category. I happen to be Jewish. I happen to be a free speech supporter. And it's difficult to say, no, people should be allowed to deny the Holocaust. But that is my position, because if you say, well, we're going to have a law against denying the Holocaust, if I'm somebody who's an Armenian, I'm saying, well, great. So it's against the law to deny the Jewish Holocaust, but it's not against the law to deny the Armenian genocide. Why do you hate Armenians so much? And then people step forward from Cambodia and from Rwanda and Gaza, dare I say. This must be a difficult conversation for somebody like you to have.
This I find not so difficult, but that's maybe because I'm in kind of lawyer mode. So in the United States, if you deny the Holocaust, you're not committing a crime, and it would be patently unlawful to make Holocaust denial a crime. We know that because there are federal cases about people Nazis marching in Skokie. It kind of follows from those cases that Holocaust denial would be very, very hard.
But that was a circuit court decision, if I recall. And I sometimes harken back to that case because the ACLU vigorously defended the Nazis. If I remember correctly, the parade went through a Jewish neighborhood containing Holocaust survivors.
Absolutely. Yeah. So I think we have to note that different countries might have reasonably different approaches. So I don't have any expertise about Germany and how it should handle that given its history, but it's not wild to say that Germany rightly criminalizes Holocaust denial or forbids it, and that Ireland doesn't. That would be an understandable approach. For my country, the Supreme Court refused to hear the case involving march in Skokie, and it's generally regarded that allowing that march was consistent with free speech law. The Supreme Court ruled a few years ago that false statements of fact can't be prevented under the First Amendment. Now, it didn't say that all false statements of fact can't be prevented, but it basically said the right response to a false statement of fact is to correct it, not to ban it. I share your thought that distinguishing one act of genocide from another isn't the most straightforward thing. Under U.S. law, and thank you for indulging my parochialism here, if you say something that's a direct threat, that can be regulated. If you say something that is initiating conspiracy, that's a criminal conspiracy, that can be regulated. You do something that's a clear and present danger, imminent lawless action, likely to induce imminent lawless action, that can be prevented. Holocaust denial, I think, is hard only kind of for the category reason that Justice Jackson identified in the flag salute case. He said the case is hard not because the principles are hard, but because the flag is our own. And that's a great sentence, that the principles aren't hard, but it's our flag. And whatever your religion or ethnicity, the Holocaust has a kind of horror and salience. But Holocaust denial, at least for my country, I'll say, it's very hard to say, consistent with standard principles, that it should be regulated without offending the First Amendment. I'll tell you something that I actually found funny. When I was being confirmed by the U.S. Senate for my White House job, I got a lot of hate mail. And it was all, so over the top that I found it comical. But the funniest one I found was one that said two things: the Holocaust never happened, and the Holocaust was great.
I've written a book about conspiracy theories. When I was going back through your back catalog 100 books ago, you've written at least one book about conspiracy theories. And I interviewed anti-Semitic conspiracy theorists. One guy, Ernst Zundel, here here in Canada who I didn't interview, but part of whose theory was that Hitler survived and lived in a base in Antarctica. There's actually a subset of hard-boiled conspiracy theorists who, as you say, the Holocaust didn't happen, but if it did happen, it was a good thing. So their anti-Semitic delusions cannot be reconciled.
The way you phrased it had logic. The Holocaust didn't happen, but if it happened, it was a good thing. The letter I got didn't have the but if it happened. It had both the proposition the Holocaust didn't happen and the proposition the Holocaust was a good thing.
I want to get into some of the specific fact patterns that you present. And when I say fact pattern, I want to make it clear to people this is not a legal treatise, although your name does appear on many legal treatises on your 17-page Amazon book catalog. So let's start. You describe this as an easy case. There's a protest on campus. And by the way, we're just assuming that these are places governed by First Amendment principles. Private or public, this is a place that is either governed or has chosen to be governed by First Amendment principles. It's a student group. They describe American officials as brutal warmongers bent on killing innocent people. And they march through campus excoriating the US government in these terms. You say that's an easy case.
There's no category of regulable speech into which that falls. So it's not a conspiracy. It doesn't create an imminent risk of lawless action. It's not fraud. It's not child pornography. It's not bribery. It's not perjury. It's very, let's say, provocative rhetoric.
Okay, so now up the ante a little bit. Now it's a student group that is in favor of rights for Palestinians. Nothing wrong with that. But they march through campus saying intifada now, intifada tomorrow, intifada forever. Is that okay?
Yeah, that's okay. People argue about this, but under standard First Amendment principles, that's okay because they are calling for resistance to something that they deem worse than unjust. That's completely okay. Now, if you give a particular meaning to intifada, it won't be quite as easy as I described. But if you want to call for armed resistance in, some country, take a country where you think things are terrible, that's not regulable. There's no general calling for civil disobedience or armed resistance exception to the First Amendment, though there is an exception to the general protection for free speech for speech that's intended to incite and likely to incite imminent lawless action. Saying that in campus is not likely to incite imminent lawless action.
Brandenburg test, if I remember correctly.
And I should say that though American parochialism is a terrible thing, the Brandenburg test is not a terrible thing. The Brandenburg test is a way of protecting even very inflammatory speech, so long as it's not intended or likely to produce imminent lawless action.
Yeah, although just a sidebar is that case is a pretty narrow standard. If I remember correctly, the facts of that case is you had I think they were literally KKK guys out in a forest somewhere, and one of them called for, I think the word he was calling for, I think, revengeance against non-white people. And I think the Supreme Court said it was protected speech because they weren't about to go attack Black people. I think a lot of people maybe listening to this, especially outside the United States, would be unsettled by how narrow that exception was, right?
Right. So reasonable people can say the Brandenburg test is too speech protective. I don't agree with that, but reasonable people do. Ask yourself, if it's too speech protective, what's a better test? Is that insufficiently speech protective? Maybe we can have a better test. I'd love to know what Canada does.
Well, we have Section 319 of the Canadian Criminal Code. It's an explicit anti-hate speech law. What's interesting is that even in Canada, that law is invoked very rarely, and the Attorney General himself or herself has to sign off personally on it. I found your book, the principles in it, it's not unrealistic to expect they'd be broadly applied to other countries, although I can't think of another country on the face of the planet that is as speech protective as the United States. I think for free speech proponents in Canada and maybe listeners in other countries listening to this, maybe it's an aspirational standard for them.
It might be thought the U.S. doesn't have it right. It wouldn't be the first time. And that the country that's dealing with student protests, broadly speaking, has it right with respect to free speech. and then engraft that country's free speech principles onto the university setting.
Maybe now is an interesting and good time to think about stuff like this, because these ideas are in flux. Like, just, you mentioned the University of Toronto. So we had this major so-called encampment at the University of Toronto, which was broken up, I guess, a month or two ago. Call them supporters of Palestinian human rights, many of them using unsettling rhetoric and tactics, set up this encampment on University of Toronto grounds. And then there was this debate about, well, is this free speech? The word quasi got thrown around. So, well, it's a quasi public space, and encampment is kind of a quasi form of speech. And conversation was very muddled because no one was quite sure whether it was a public space. No one was quite sure whether setting up an encampment is speech. And then you get into this sort of reasonable limit, mushy language of Canadian constitutional law. So the encampments have made a lot of people, including progressives, especially progressives who run universities as administrators, think a lot about these principles. So in that way, it's an opportune time. And you specifically, you don't shy away from some of the hard cases. You talk, in one of your case studies, you talk about students chanting "from the river to the sea," which many critics of that kind of protest say this is a plain reference to cleansing the area from the Jordan River to the Mediterranean Sea of Jews. And so this is hate speech, it's exterminationist speech. If I understand you correctly, you're saying, no, this is my language, not yours. You have to take the rhetoric in its most charitable light. The most charitable interpretation is not call for the extermination of Jews.
There's a lot to be said about "from the river to the sea." And I should say that while for me, consistent with, I guess, the evidence, writing is really fun.
Apparently, you can't stop doing it.
I can. It's not like heroin.
I know. You're like the smoker who says, oh, I can quit any time, but today's not a good day and tomorrow is worse.
I like it. But some of these cases were painful to discuss, involving racial stuff in particular. That was very painful to discuss. Okay, let's talk about "from the river to the sea." In the U.S. setting, there isn't a hate speech exception to the First Amendment's protection of speech, so we don't have the category. If someone says "from the river to the sea," one question is, does that fall in any category of regulable speech? That's the core question. And New York, if people are saying "from the river to the sea," that doesn't fall with any category of regulable speech. Now, one question is, what are the effects of that statement? Is it going to produce, violence at synagogues? Then we're talking about clear and present danger, maybe. So if I walk around New York City saying "from the river to the sea," I think people might think that I had kind of problem. Why am I saying that randomly? But it would be very surprising if anything bad happened against Israel. By virtue of my saying that, it's more likely that people would think, I don't like Israel or something, and they'd be mad at me, but there wouldn't be a regulable thing. So if people are saying "from the river to the sea," let's say on campus, and this is a painful one, and different countries might want to handle this differently in different institutions. But if people are saying "from the river to the sea," that could mean any number of things, I think. If it means horrible violence and such, that's different from whether it's a statement of an aspiration toward an imagined future that wouldn't be brought about through violence, or if it's just maybe more a statement of complaint, severe complaint about what is, by the lights of many, terrible status quo. So it could mean any number of things. But even in its most, let's say, aggressive, the question is, does that fall within a category of regulable speech? If someone says some nation, pick your nation, should be blown off the face of the earth, that's a terrible thing to say. I can't think of a nation for which that would not be a terrible thing to say. But that's protected.
I now have Section 319 of the Canadian Criminal Code in front of me. I'm actually surprised how close it is to, at least in nominal terms, to the Brandenburg test. I'm going to read it here. Everyone who, by communicating statements in any public place, incites hatred against any identifiable group where such incitement is likely to lead to a breach of the peace. And then it goes into the consequences. That's actually very close to Brandenburg, although in practice, for instance, one of the few cases in which it was applied, there was A very unfortunate case, a former community leader who had substance abuse issues and started ranting about how it was pretty horrible. He said like Hitler was right to throw Jews in the ovens, like stuff, like really awful stuff. As horrible as his rhetoric was and anti-Semitic, there was no way people were going to listen to it and act on it.
That is extremely interesting. It's not, the Brandenburg test is a little more speech protective than that. It says directed to incite, likely to incite imminent lawless action. That's a little more speech protective.
You take pains to talk about situations in which it's a lot more personal. So for instance, one quote here, this is a case study. If we run across you in a secluded space, you're toast. We don't want your type around here. How would a university governed by First Amendment principles deal with that?
That's a true threat, so that can be stopped. The Supreme Court has distinguished between statements of politics that are demeaning or humiliating or extremely agitating or make people feel unsafe. Those are protected, and true threats. So if you issue a true threat, something that is intended and understood as a threat of violence, that can be stopped.
I just learned that you're an elite squash player. Do you still play?
I do. I can't say that I'm elite, but I'm avid. I play about 4 to 5 times a week. I'm going to play today. I've lost to many Canadians in squash and maybe beaten a few.
I actually know a Canadian named Jeremy Freiberg who went to Harvard Law School and at one point I think was in the top 100 in the world in squash. Did you ever play against him?
I didn't, but I did play against Michael de Saulnier, a Canadian who was at one point the best player in North America, which with the old ball meant he was the best player in the world. I played him once in a league match. I was playing number 1 for Harvard grads. He was playing number 1 for Harvard College. Hi, Michael de Saulnier, you're one of my heroes still. And I won the first game 18-17, which was a shock to both of us. And then he destroyed me the second game. I think it was 15-2.
Were you playing with a double yellow dot?
Yeah, the old ball. Everyone now plays with the softer ball.
Well, I have even more admiration for you.
I had a lucky first game, but he was in another league.
I never saw him play. I saw Jonathan Power play, who was another great Canadian.
Incredible.
I'm going to title this podcast Great Canadian Squash Legends, just to make sure the maximum number of people listen to it.
Amazing squash players.
Cass Sunstein's new book of many is called Campus Free Speech, A Pocket Guide. Thank you so much for being on the Quillette podcast.
Thank you. Great pleasure.
Thank you for listening to this episode of the Quillette podcast. Quillette is where free thought lives. We are an independent grassroots platform for heterodox ideas and fearless commentary. If you'd like to support the podcast, you can do so by going to quillette.com and becoming a paid subscriber. This subscription will also give you access to all our articles and early access to Quillette social events.